This is Barry Zelma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to talk about contract documents and their importance to any insurance claim dealing with a construction project or construction defects. Contractors and building owners can purchase a standardized and industry-accepted form that is less expensive than asking an attorney to draft a specific contract from scratch for the construction of a residence or commercial building. Although on a large project, it is often a good idea to involve counsel to review or modify the standardized forms to protect the client's interests. Generally, sources that create construction contracts are equipped to protect standardized form users because they are familiar with all the new case law that affects the interpretation of contracts, new statutes that affect the interpretation or application of the contract terms, the need to resolve legal issues that become apparent so that they will not arise in future contracts, the need to conform to changing building codes and construction-related statutes, and the need to conform to changing insurance policy wording and regulations. The most extensively used standardized forms are those that have been developed by the American Institute of Architects, the AIA. AIA contract documents have defined the contractual relationships in the design and construction industry for 120 years. AIA contracts can save the parties time and money, are up to date and constantly revised, provide assistance in dealing with new design and construction issues. The contracts can now be purchased in MS Word format. AIA contracts are commonly used in the construction industry. The American Institute of Architects has created one of the most useful sources of contract documentation. The organization was established on February 23, 1857, with 13 architects who met to create an architecture organization that would promote the scientific and practical perfection of its members and elevate the standing of the profession. Before this time, anyone could be called an architect, including masons, carpenters, bricklayers, and other members of the building trades. No schools of architecture or architectural licensing laws existed in 1857. Today, AIA's standardized contracts and administrative forms are recognized throughout the design and construction industry as the benchmark documents for managing transactions and relationships involved in construction projects. In addition, a significant body of case law concerning contracts for design and construction exist, interpreting the language of the AIA standard forms. The more case law there is interpreting standard contract forms, the more certainty the parties to the contract have concerning their rights and obligations under the contract. Contract terms that have been tested in the crucible of litigation are less likely to be the subject of future litigation. The AIA has helped establish many practices that are common in the construction industry today, including the following. 1. Arbitration. 2. The one-year correction period. And 3. the architect's role in deciding disputes. AIA documents are used almost universally in the construction industry on major construction projects. On smaller projects, contracts are shorter and less demanding. The AIA regularly revises its documents to take into account recent developments in the construction industry. New documents are standardized for different types of construction management and for international practice for use by designers, builders, developers, architects, contractors, and others in the trade. In Nebraska, for example, the Supreme Court held that the meaning of a construction contract is a question of law, not fact. And after considering an American Institute of Architects standard form of agreement, because the contract contained a waiver of subrogation, it applies to damages to both the work and the non-work property. The AIA reports that its drafting process is, quote, a thorough and deliberate approach that strives to achieve a fair balance among interests affected by the contract documents. The process is based on the cooperative input of a documents committee of practicing architects who have been appointed based on their experience, regional diversity, and variety of practices. Beyond the input of these committee members, the AIA also solicits feedback from owners, general contractors, engineers, subcontractors, sureties, lawyers, insurers, and others. By considering the opinions of a broad range of disciplines, the AIA strives to publish documents that account for the best interest of all parties affected by them, close quote. AIA calls its different categories of documents either families or series. This double method of organizing the documents is designed to make it quicker and easier for users to select the documents appropriate for their projects. Documents in the same family are coordinated to tie together the various legal and working relationships on the same project types or delivery methods. They are linked by common terminology and procedures so that various forms can be adopted by reference into the wording of the basic contract. The AIA has created an A series of contract documents for agreements between an owner and a contractor, a B series of agreements between an owner and architect for professional services, a C series for agreements between an architect and other professionals, including engineers, consultants, and other architects, and a D series known as the architect industry documents for a range of products. AIA's standard documents are intended to be used in their original printed form, and like most standard documents, are designed to make a project flow easily and without problems, and to protect the rights of the parties involved if there is a problem. Modifying standardized documents without appropriate legal advice is fraught with peril and should always be avoided. AIA documents are intended for nationwide use. They are not drafted to conform to the law of any one state. People using the standardized contracts must be cautious and seek counsel from a knowledgeable attorney to be certain that local jurisdictional or substantive law does not contradict or make unenforceable the standard language of the AIA contracts. With that warning, however, AIA contract documents and other form contracts can provide a solid basis of contract provisions that are enforceable under the law existing at the time of publication in most jurisdictions. Now, there are alternative sources for contract documents. AIA is not the sole source of standardized contract documents. Other publishers have created standard contract forms, including the Canadian Construction Documents Committee, the Design Build Institute of America, the American Subcontractors Association, and many other sources available on the Internet. Forms can also be purchased at building supply stores or may be drafted by local counsel or by independent contractors or subcontractors. For example, some contractors use a one-page form with the terms and conditions attached as an appendix. Others attempt to draft complex contract documents by cutting and pasting parts of contracts presented to them by other builders, architects, and developers. This practice is hazardous to the contractor or developer's bottom line. To be understandable, a contract must be internally consistent. When bits and pieces are taken from various sources and put together, the document can become incomprehensible and invariably create future litigation. If the contractor or developer refuses to use a standardized form, it would be best to obtain the services of an attorney familiar with the construction industry to draft a contract that is specific to the needs of the client, is internally consistent, contains conditions that are favorable to the client, contains protection for payment of the contract price, and contains an effective arbitration clause to avoid litigation. Since construction contracts are unique, it is often in the best interest of the parties to an arm's-length construction contract to retain local counsel to create a contract to their specifications after the major issues are resolved by negotiation. The contract would, in the precise contractual language that attorneys use, set out the positions of both parties, explain the duties and obligations of both, and make it difficult, if not impossible, to fail to fulfill those requirements. The cost of hiring an attorney before the contract is completed can save hundreds of thousands of dollars in attorney's fees if there is a contract dispute. An owner presented with a non-standard contract should not accept it as presented. All contracts, except contracts of adhesion, are subject to negotiation. It is imperative that both contracting parties review the contracts carefully with the assistance of competent counsel. All construction professionals are familiar with AIA and other standardized documents and can quickly evaluate the proposed transaction based on the modifications made to the standardized documents. If those modifications stand out, if the document has been retyped or scanned and the modifications are blended into the text so that the changes are not readily apparent, the person modifying the document can be charged with attempt to deceive the other parties to the contract. Regardless, every contract should be read in full before any reasonable person would sign it and enter into a contractual relationship. Therefore, modifications may be derived from another type of document published by the AIA. These are model documents. The model documents use standardized language to modify contracts to meet the particular needs of the contracting parties. The language is intended to be reproduced and adapted by users to give a customized feel to standard documents. Standardized documents are designed to be used as written, with the parties merely filling in blanks for the names of the parties, the location of the project, and the project price. Model contracts, on the other hand, are designed as a foundation for a contract that is subject to customization to meet the needs of the parties. The parties can effect a cost saving by instructing counsel to use the model forms as the basis of a customized contract. This video was adapted from my book, Construction Defects and Insurance, Volume 1, which is available as part of an 8-volume set from Amazon.com as both a Kindle book and as a paperback. If you found this video to be useful or of interest to you or your colleagues, please pass it on to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn of future videos and future blog postings. Thank you for your attention.